Shannon, you can put us on the record. We're waiting for everyone to have an audio connection. As soon as I see that, we will start. All right, looks like we have a connection. There's a very long name to this case. In the matter of the petition of the Jackson County Treasurer. Counsel, would you each state your appearances, please?
Thank you, Your Honor. Eric White appearing on behalf of the Jackson County Treasurer, Karen Kaufman.
Yes, good morning again, Your Honor. Larry Opaleski appearing on behalf of the movements Christine Bader and Sandra Keeble.
Judge, I think I'm here on the wrong case. This is Brian Beach here on the Kadena matter.
You're welcome to join us, though.
Yeah.
I'm not seeing that one on my document, sir.
Okay. All right. I will double check. It was a motion to stay in the Kadena matter at 10 a.m. today.
That's not on my docket, so I don't have the file.
Okay.
You might want to check with Patty Clark, my civil secretary. Maybe she can tell you what's going on with that.
All right. Thank you, Judge.
All right.
All right. Have a good morning.
You too. Okay, Shannon Opalewski is spelled O-P-A-L-E-W-S-K-I. Okay, gentlemen, Mr. Opalewski, this is your motion. I've read the motion. I've read the response. I've read the Supreme Court decision in Raffaele versus Oakland County. It certainly would appear, based upon Raffaele, that your clients have a valid claim for recovery of surplus following the tax sale. But the real question is this the right place? So Mr. White has clearly indicated in his response that you haven't even identified any basis other than the fact that the claim exists for why I should be entertaining the claim in the context of some form of post-judgment relief. So if you could address that, please. I think that's really where I'm going to have to direct my attention today. Go ahead.
Absolutely, Your Honor. And as you mentioned, Brother Counsel did raise that objection in his response. And so what I would say, first of all, is under MCR 2.612, I think there's a good argument that you have the authority under that court rule under sub C1F. That is not our main argument, but I do think if for no other reason, I think Your Honor does have the discretion under that court rule to award this. But what I really want to point the...
Hold on, let me get there just for 2.612 C1
F.
Oh no, sorry, C1F. All right. I don't see a C1F. I see an F.
Any other reason justifying relief? It's that catch-all at the very end, Judge.
Oh, I see the problem. Sorry. Let me get to the right place. All right, thank you. Go ahead.
Thank you, Your Honor. And as I was saying, that's more of an alternative argument that we would bring. And I really just addressed it because Brother Counsel raised it in his response. I do think Your Honor would have discretionary authority under that rule. But the main grounds that I would bring is courts make these sorts of rulings all the time. We see it in the dispersal of surplus funds from a mortgage foreclosure. That's under MCL 600.3252. Of course, this is a slightly different set of circumstances that we have here. And the state has actually said that this is the method that's going to be used in the future for dispersing these funds. Public Act 256 of 2020 was passed in December. All the forms and other mechanisms that are going to be used for handling these claims in the future are not ready yet from the state. But under MCL 211.78T, these claims are to be brought in the same proceeding in which the judgment of foreclosure of the property was effective. And that would be this case, Your Honor. The county also raised the issue of that this is an in rem proceeding rather than in personam. And I would agree with that, Your Honor. And I think how we tie that into Raffelli is the Raffelli court said that these surplus proceeds are not damages, they're actual property that is to be returned to the original property owner. And when they're viewed as property, which they are, I think it's very clear that the court has jurisdiction over these proceeds pursuant to its in rem jurisdiction. And I do want to quickly address the issue of the proper parties, because that's something that the county raised as well. Again, this is the method that the state wants us to use, and I'm sure Your Honor will be seeing a lot of these claims in the next few years moving forward. So it's going to be done this exact same way. But even if the court is inclined to want the actual county brought in as a party, we can very easily do that via joinder or even interpleader under 2.207 or 3.603. So I hope I've been helpful in my response here, Your Honor.
Well, and I haven't had a chance to, Mr. White hasn't had a chance to look at the specific authority that you're now stating that you're relying on. It certainly does appear to me, based on Raffaelli, that if you were here today on a new civil action seeking recovery of the surplus funds, based on Raffaelli, there would be no basis for me to question the validity of your complaint, the availability of that avenue as a valid remedy. But what I have before me today is a different creature. For the first time, I'm hearing that you're telling me that this is what the legislature has devised prospectively. I think it's only fair that we give Mr. Well, if you're going to ask me to grant relief on that basis, you're going to have to file some kind of supplemental authority. Give me the opportunity to look at that. Give Mr. White the opportunity to look at it and respond. What I would suggest to you that the other thing available to you, and granted there's a filing fee involved, but you get to recover your costs if you're successful. Looks like you'd be able to recover those costs because it looks like you're probably going to be successful. It appears indeed there was a surplus from the sale. Do you want to spend more legal fees in this action, trying to convince me that I can do it in this action? Yeah, I leave that up to you. Or do you want to simply just withdraw this motion and file a new civil action? Because you could end up there. I could ultimately say to you, no, Mr. Opalewski, I think this is the wrong place. You need to start a new action. And you absolutely would be able to do that. I leave that up to you. I'm not going to ask you to make that decision today. What I will do is give you 14 days from today's date to file your supplemental authority based on the authority that you just raised on the record today. I think it needs to be in writing, since I can anticipate there might be some future litigation of this issue or appeal. Give Mr. White 7 days to respond to that. But if you choose, in the meantime, simply to withdraw your motion and file a new civil action, you might save a few dollars in attorney fees. So I'll leave that up to you. So, Mr. White, I haven't given you much chance to talk today. Do you have anything to add to this discussion?
Well, I know of two attorneys who are aggressively soliciting clients on this issue. And as you can tell, the Fox matter that I cited is been certified for class action. There are a number of remedies that are all out there. And I'm familiar with the Public Act. Clearly, Mr. Opalewski's client's going to receive some funds. I'm just not sure what it is. If they have a little bit of patience, I think it will sort itself out. The forms that that Mr. Opalewski's talking about haven't been put forward yet. I know you're shocked that the state would pass a law and not have everything ready. But
Do you have any kind of prediction, Mr. White, as to when that might happen?
no, I stay on top of it, but I haven't really heard much from the treasurer on that recently. There's a number of things going on. There's also, I think another reason why you probably wouldn't want to grant the relief today is there's some other provisions within that Public Act that would take additional funds to the treasurer for their costs. So it's not simply a mathematical equation here. I think that form is going to try to take that into account.
So, having said heard that and what I've already said, Mr. Opalewski, I would be willing to grant you a little more than 14 days if you'd like that opportunity to explore a different avenue. But if you want to proceed with this motion, and you're certain of that today, I would want your authority within 14 days. And then Mr. White, is 7 days after that sufficient for you to respond?
Certainly, Your Honor. Thank you.
So that I have the whole thing in front of me. I don't want to just ramble through all of this stuff and force Mr. White to address what you've raised orally. I think it needs to be stated in a supplemental brief.
Yeah, thank you, Your Honor. I certainly don't want to waste the court's time or drive up expenses for either my client or the county here. So I will certainly communicate what you're telling me back to my clients, and we'll make a decision from there. And I do acknowledge that this is kind of uncharted territory that we're in. So it's
Sure.
The Raffelli ruling, as you stated, Your Honor, is pretty clear, but how we get there isn't quite clear yet. So I can appreciate the what we're dealing with here.
All right. If you could please prepare and submit an order consistent with my ruling today. And if the two of you agree that you want to extend or delay that for some period of time, you're free to do that. If you don't agree, then file your authority and I'll address it.
Very good.
And then we'll just once that's happened, Mr. Opalewski, just renotice your motion. You don't need to file another motion.
So would you like me to call it an adjournment, Your Honor, in the order?
I'm sorry, say it again.
So in the order, would you like us to call this an adjournment of the motion, or how do you want us to style that?
It doesn't matter. You can call it an adjournment if you want. In any event, it's an order for supplemental briefs. If you want a title for it.
Very good, Your Honor. Thank you.
Okay.
Great.
Thank you, gentlemen.
Yep.
Good day.